Justice Barrett?
Ms. Blatt, I think one, not yet. I think one of your compelling consequentialist arguments is this argument about the states going wild if the FSIA doesn't apply. But presumably, states have broad grants of criminal jurisdiction in their courts. Is it, have states, I'm just wondering if you know, as an empirical matter, have states tried to prosecute commercial entities or instrumentalities? And if so, is it common law immunity that holds it back? Or is this kind of the finger in the dike so that, the instrumentalities can say, oh, no, the FSIA deprives you of jurisdiction?
Well, if you've just ruled against me that the FSIA doesn't apply, they don't have anything but common law immunity, whether that's a federal common law immunity that applies in state court or what have you. But empirically,
right. I'm just talking about I'm not talking about going forward. I'm just saying right now, have states even tried it?
No, because there's been no decision that has said that I mean, you're the Supreme Court, so no. But OPEC fixes prices, so. That's an antitrust violation.
Sure, but prosecutors are clever, right? I mean, I'm just wondering if the FSIA is the only thing that's holding this back in its provision depriving states of, jurisdiction to adjudicate such claims. Have they tried it and made these arguments? And you're just saying you think not?
I don't know
has
of
ever
any.
thought that.
I have seen cities, I think, prosecute. I think Mexico for environmental violations, but it was like really random. But it was really random.
Okay, thank you. But it seems though, kind of going back to this immunity point, in other countries, I assume that this is a matter of international law. The sovereign immunity say that the United States may enjoy, that it's not controlled by jurisdiction there. So why would it all fall apart if it's controlled by immunity doctrine and not jurisdiction here? They have
Maxie, they have comparable FSIAs in some of places like South Africa and Israel. But yes, it's just been, I mean, the world has been around for 7,000 years and no country has ever tried another country. Well, it's just never happened. And so to sort of say, well, some Second Circuit case can figure it out, district courts will muddle along as long as the president says it's okay. Our country's different, we're special. Hopefully no other country will retaliate.
Just one more. Let's say that I disagree with you on the 3231 point, and so we are talking about the FSIA. And I'm looking at 1604, which broadly, if you're just looking at 1604, and they have these arguments about context of civil cases, but just looking at 1604, that language seems to grant immunity here. But then, the government says that when you get to 1605, that all of a sudden you're doing this switch. Oh, no, now the exceptions only apply in civil cases. I think, that's a pretty good argument. What do you have to say to that?
Just 1330. Again, the FSIA, I know it's a couple pages down in a blue brief, but if the act of the FSIA starts with section 1330, it says there is jurisdiction for cases falling within the exceptions in 1605 and 16 through 1607. So the first provision of the FSIA.
But if we disagree with you about the criminal grant of jurisdiction, does that argument work as well?
Not as well.
Mr. Conley, what are the limits of your theory? Could someone who finished paying their loans off, right last year, sue because they were disappointed that they weren't included for reimbursement?
No, I don't think so, because there's no mechanism by which the Department of Education can write those borrowers a check. And so their injuries are not redressable. Here, there is a mechanism under which the secretary can forgive Ms. Brown's debts, forgive Mr. Taylor's debts, and that's the difference.
What about the Chief Justice's lawn care person who doesn't go to college, starts a lawn care business, but as the chief said, this person has some fairness concerns and feels like this shouldn't have happened and kind of level up or level down and wants to level down?
Sure. Again, the Secretary of Education has no power to give any money to that individual or do anything like that. And so even if he could come up with a concrete interest, it couldn't be redressable.
Could have persuaded him not to do it would be, I take it with the fairness concern and the hypothetical the chief posed you. I think it would have been to say, well, this isn't fair. You're not doing this for me, so you shouldn't have done it for anyone. But you're not taking the position that that would be
no, he would not, because you have to have concrete interests, has to be particularized, can't be abstract, and so.
So it's not just the getting shut out of notice and comment.
Correct. These individuals have concrete interests. There was a $400 billion debt forgiveness program that was created, and the respondents have debts, and they're not being forgiven. And if it had gone through the proper process, negotiated rulemaking and notice and comment, we could have argued that our debt should be forgiven too.
Oh, no, I'm sorry. So speaking of this question of what are the implications of this, and Justice Jackson's points about liability and immunity overlapping, it seems like one of the responses to should we worry about this is, well, it's going to be the rare kind of claim that could be based on recommendations. So speaking of that, what is the government's position, if you have one, on whether if the plaintiffs below lose tomorrow in Twitter, should we just send this back because there isn't? I mean, you said the government's position is that there is no claim.
Certainly our position, we haven't analyzed the Gonzalez complaint in detail, but that is our position as to the Twitter complaint, and Mr. Schnapper said he doesn't perceive a material difference between the two. Now, presumably the court granted cert in both cases because it thought it would at least be helpful to clarify the law both as to the Anti-Terrorism Act and as to Section 230C1. But if the court no longer believes that, or if it resolves Twitter in such a way that it seems evident that its decision on the 230C1 issue wouldn't ultimately be outcome determinative in Gonzalez, then it could vacate and remand for further analysis of the ATA question. That would be a possible course of action.
Justice Barrett?
I'd like to take you back, Mr. Schnapper, to Justice Sotomayor's questions about the complaint. It seems to me that the complaint in this case is materially indistinguishable from the complaint in tomorrow's case. Do you agree? Same
in which case? I'm sorry.
In tomorrow's case, in the Tomno case, the Twitter case, and this one.
Pretty much.
So they're both relying on the same aiding and abetting theory. So if you lose tomorrow, do we even have to reach the Section 230 question here? Would you concede that you would lose on that ground here?
No. There was a motion to dismiss in tomorrow's case on JASTA grounds. It didn't get decided. So if we lose tomorrow, the defense will be free in this case to move to dismiss. But we'd be entitled to try to amend the complaint in this case to satisfy whatever standard you establish tomorrow.
Okay, let me ask you this. I'm switching gears now. So Section 230 protects not only providers, but also users. So I'm thinking about these recommendations. Let's say I retweet an ISIS video. On your theory, am I aiding and abetting, and does the statute protect me, or does my putting the thumbs up on it create new content?
We don't read the word user in that broadly. There's not been a lot of litigation about this. We think the word user is there to deal with a situation in which one entity accesses a server, YouTube, for example, and then someone else uses that entity. Like when I go to FedEx office. FedEx office is the user that is accessing my email. And the statute protects them when I look at the FedEx computer and find the defamatory.
Let's say that I disagree with you. Let's say I'm an entity that's using the service, so I count as a user. You know, my computer is accessing the servers when I retweet the image. On your theory, could I be liable under JASTA for aiding and abetting? Without, do I lose 230 protection if I created new content?
Whether it's enough for JASTA is a separate question.
Okay, right.
The question is
enough.
it outside 230?
Is it outside of 230?
Right. And our view is the statute doesn't mean anyone who's a user who conveys third-party libel is protected. If you, let's say that you read a book and it says John Doe is a shoplifter, and you send an email that says John Doe is a shoplifter, you're using the internet. You're using the email system. But nobody thinks that Section 230 is a blanket exemption for defamation on the website as long as you're quoting somebody else. Retweeting is a very automatic way of doing it. But if you start down that road, you'd end up having to hold that any time I send a defamatory email, I'm protected as long as I'm quoting somebody else. I don't think anybody thinks
I guess I don't understand. I mean, let's see. I guess I don't understand logically why your argument wouldn't mean that I was creating new content if I retweeted or if I liked it or if I said, check this out. Why wouldn't that?
You would be, but I'm advancing an argument that gets to the same place, which is you're not a user within the meaning of the statute just because you go on email or YouTube or
Let's
Twitter.
say I disagree with you. Let's say that I think you're a user of Twitter. If you go on Twitter and you're using Twitter and you retweet or you like or you say, check this out, on your theory, I'm not protected by Section 230.
Yeah, that's content you've created.
That's content I've created. Okay. And on the content creation point, let's imagine, it seems like you're putting a whole lot of weight on the fact that these are thumbnails, and so it's something that YouTube separately creates.
Yes.
What if they just screenshot? They just screenshot the ISIS thing. They don't do the thumbnail. Then are they?
That's pure third-party content.
That's pure so this is just about how YouTube set it up.
That's correct in this context. And it gets back to the conversation we were having earlier about that this is a new technology that didn't exist in 1996, and rather than ask Congress to write the statute to cover it, they just went ahead and did it.
Okay, and last question. Turning to the statutory text, so it seems to me some of the briefs in this case are focusing on what it means to treat someone as a publisher, treat an entity as a publisher. You're not really focusing on that and the traditional editorial functions argument. I mean, you're really focusing on the content provider argument, correct?
No, well, we've advanced views as to each element of the claim.
But today, you've really been honing in on this. Are you actually creating content or just presenting third-party content?
Well, I've been answering, that's where the questions have taken us. But our view would be that you're not being treated as a publisher of the video just because you published the thumbnail.
Okay, thank you.
You're not being harmed by the thumbnail.
Thank you.
Barrett?
Okay, so I'm having a little bit of difficulty isolating exactly your argument. So let me put it to you this way. So it seems to me that the flaws in the Ninth Circuit opinion that you see are, one, in the unit of analysis, because they're focusing on the enterprise rather than the act, or as Justice Gorsuch said, the person who committed an act. But in any event, you're saying that we need to specifically focus on the act. Here, the Reyna bombing, didn't have to know it was going to be there. Okay. Second is the substantial assistance, and third is the knowledge requirement. So I just want to make sure I understand the difference between aiding the enterprise writ large and aiding in an act, because you've said in response to a few of my colleagues, including just now Justice Kavanaugh, that if you know bad people are using the platform and you don't do anything about it, and I'm pressing you now on what you said about specific knowledge of the specific accounts, I guess. Why, if you know ISIS is using it, you know ISIS is going to be doing bad things, you know ISIS is going to be committing acts of terrorism. So what work does training your focus on the specific act do in that case? Because aiding ISIS is aiding the commission of particular acts in the future. How specific must the knowledge be? There must be a range between aiding the enterprise and knowing the time, date, and location of the particular act, right?
So I'm not resisting, as a categorical matter, the use of the word, and Halberstam's use of the word enterprise. My position is that where the court below erred was in substituting as the object of whereas the statute clearly said the object is either the act of international terrorism that you're abetting or the person who committed that act you abetted that person in committing the act. Halberstam points out that, look, if you have a situation in which, you have a partner, you have a symbiotic relationship with a partner in which every week there's a property crime, and he brings home the jewels and you smelt it down and sell it, that you can be deemed to have knowingly provided substantial assistance to the act where ultimately he gets caught, the Halberstam burglary. The fact that you were part of this series of discrete acts establishes step 3 of Halberstam. That's very different from basically saying that all you have to do is aid and abet ISIS generally. And the clarity with which the Ninth Circuit made that error is actually revealed. I don't have the page number, but it's in the the discussion of the facts of Gonzalez before it gets to Tomna. The Ninth Circuit says, quote, the parties dispute whether the relevant, quote, principal violation is ISIS's broader campaign of terrorism or the Paris attacks. It chooses the former and therefore says anything that ISIS does, that you assist anything that ISIS does, is assisting an act of international terrorism.
Okay, so
Now,
it's a level of generality. You were kind of going back and forth with Justice Kagan about the same issue. It's a level of generality. You might know, I guess I'm trying to figure out if the Ninth Circuit's error matters, because you might know that you're aiding ISIS, and as I said, aiding ISIS is going to result in aiding some terrorist attacks. But you're saying that the plaintiff would have to allege facts sufficient to show that Twitter was being used to plan this attack. I'm putting aside right now the knowledge and substantial assistance part, but that's the level of inquiry.
You have to be, the plaintiff has to plausibly allege that substantial assistance was provided to the act of international terrorism that injured the plaintiff in the case.
So that these particular terrorists were communicating via Twitter for the Reina attack. Putting aside what Twitter knew about it, would need to be looking at tweets or accounts going back and forth to share the details or recruit people to help participate in this bombing.
No, I mean, the Twitter would have to know there are accounts. We know
I'm
of
not
these.
talking about Twitter's knowledge. I'm just
Okay.
talking about the unit of analysis.
Okay, the unit of analysis is that there are allegations in a complaint that there were Twitter accounts or Twitter posts that in fact substantially assisted this terrorist
Bombing.
attack.
So not the general recruiting.
Not general
All
recruiting.
right, I think I understand you. And on substantial assistance, you kind of conceded to Justice Kagan in her hypothetical that it would be substantial assistance if Twitter knew that these accounts were being used and didn't do anything to take them down.
Yes, the particular account.
So that would be, because I'm just wondering what the test for substantial assistance is, right? I mean, there's a lot that goes into presumably pulling off a terrorist attack. So is providing the means of communication, you concede that would be substantial assistance?
I mean, again, it would depend on what it turned out was going on in those accounts that Twitter actually knew about. And if Twitter knows about, and this goes to Justice Sotomayor's question about willful blindness. If in my hypothetical, the Turkish police, the Istanbul police come and say, there are 10 accounts, 10 Twitter accounts that appear to be involved in planning some sort of terrorist attack here. And Twitter basically says, not our problem. That is the level of knowledge. And if
That's
in fact,
knowledge. I was asking you about substantial assistance.
I see. If what was in those posts in fact, were the planning and preparation and commission of the attack that happened to occur at the Reina nightclub, that would be substantial assistance.
Okay, so to clarify, you're not saying that merely using the platform is enough, but it would depend on how significant the communications on the platform were to the attack?
Correct.
Okay, and last question. What daylight, if any, do you see between your position and the government's position?
Very little. I think what the government says, I mean, with respect to the relevant object, we agree. It's the act of international terrorism, not ISIS generally. With respect to knowledge, I think they also agree. The particularity in a context in which there's this remote general arm's length provision of services. If we disagree, it's on how one calculates, I guess, or characterizes substantiality. The government says that there has to be a substantial causal link between the assistance provided and the act that occurred. And in principle, I don't disagree with that.
So no daylight, really?
Can
Okay.
I reserve judgment until I hear Mr. Needler's
Okay,
answers?
you started out saying very little, and then you said in principle, but that's okay. I'll let Justice Jackson have a shot.
I'm not sure.
General, I'm thinking of an Arkansas versus Texas. It was significant in that case that Arkansas owned the land of the university. So it does seem that Missouri has created the separateness with respect to the liabilities of Mohila. What if, and I'll ask this to the other side, it's not really clear to me what happens to Mohila's assets. I mean, what if Mohila itself dissolves? There are no shareholders. I mean, does your answer change if, even though Missouri is not responsible for the liabilities, it does have an ownership stake in the assets of Mohila?
I think it's clear under state law, Justice Barrett, that Missouri doesn't have that kind of ownership interest in the assets of Mohila. And I would point in particular to Missouri Revised Statute 173.410. This is the provision that makes clear that Missouri cannot take the assets of Mohila and appropriate them. They don't go into the general treasury. It makes clear instead that those assets are under Mohila's exclusive control. So I think as a matter of state law here, we don't have anything like the Arkansas case that you just referenced. And as well, the flip side of that is the provision of state law that likewise says Missouri is not going to be liable for any agreements or obligations or liability of Mohila, so that if Mohila goes out there in the world and harms someone, the state's not on the hook for the damage. And that's another distinction from the Arkansas case where under state law there, it was clear that a suit against the instrumentality was a suit against the state itself.
Would you have the same position with respect to federal corporations? Like, what about the FDIC or organizations like that? What if the agency didn't want to sue? Could the United States sue to protect the federal government's interests if the corporate identity was separate, like here?
No, I think that our principles would apply with respect to our own instrumentalities. We could, of course, sue to protect distinct rights and interests of the United States. And so respondents have cited some cases, for example, where an instrumentality entered into a contract on behalf of the United States in the name of the United States as its agent, and we had a contract right that we could enforce in our own name. Or there was another case that involved a statutory right in the tax context to offset, and the United States was permitted to sue on that basis because it had its own rights and interests. But we've never done what the states are doing here, and in the absence of any underlying contract right or statutory right or trust right, just asserted this all-purpose ability to blur the distinction between the sovereign and instrumentalities when they're separately incorporated in this way.
General, I'd like to put aside the Lewis and Clark Fund for a minute, and I want to return to the direct injury argument, the Mohila as an arm of the state argument. Justice Sotomayor was pointing out, statutorily, Mohila has the right to sue and be sued. The state doesn't have responsibility for its liabilities, and the state has disclaimed any claim to the assets. Is that correct?
I would disagree with the last point. I don't think
Okay.
the state has disclaimed any interest in the assets.
So explain to me why. Because on the one hand, you have, in Missouri Statute 173.420, you have the last sentence says that nothing in these sections shall be construed to deprive the state and its governmental subdivisions of their respective powers over assets of the authority. But then in the next section, 425, it says, no asset of the authority shall be considered to be part of the revenue of the state. So which is it? I mean, because it would be hard to see how a win for the state would benefit Mohila or a win for Mohila would benefit the state if the assets are completely separate. You don't get any money out of it. Putting aside Lewis and Clark, because I'm not really interested in that.
So, Your Honor, to go to the second provision you read, 425, it says no asset of the authority shall be considered to be part of the revenue of the state within the meaning of a specific state constitutional provision. So I would then say that's only for a limited purpose. The prior provision that you read, where the state has preserved its authority over Mohila's assets, shows that any residual interest in Mohila's assets belongs to the state. So we cited the reciprocal casualty exchange case in our brief that shows that the legislature could abolish an entity like Mohila, and if it did, the money would come back to the state. So the state does have the ultimate interest in the property of Mohila.
If the state wanted money from Mohila right now, the state just wanted to pull assets out, say, because the state was going to make a decision to fund the Lewis and Clark Fund, does the state have the authority to do that?
Acting through the legislature, it does.
Okay.
And I think the Lewis and Clark Fund is actually a great example of that. So the Lewis and Clark Fund wasn't created until 26 years after Mohila began its operations. And at that point, the legislature came in and said, Mohila, you have to start giving this source of funding to the state. So the legislature can come in at any time and request money.
Do you want to address why Mohila's not here?
Mohila's not here because the state's asserting its interests. Mohila doesn't need to be here because the state has the authority to speak for them. And that brings me to...
Why didn't the state just make Mohila come then? If Mohila is really an arm of the state and all of this would be a lot easier, I mean, the Solicitor General conceded that if Mohila was here, Mohila would have standing. If Mohila is an arm of the state, why didn't you just strong-arm Mohila and say you've got to pursue this suit?
Your Honor, that's a question of state politics, but we believe as a matter of law that the state has the authority to assert its interests. Under the factors in LeBron, under the factors that the Missouri State Supreme Court recognized in casualty reciprocal exchange, if it's a state-created and state-controlled entity that performs government functions, the state can speak for it regardless.
Justice Barrett?
2 questions, one on merits, one on standing. First, on the merits, do you agree that this administration and the prior administration had authorization under the HEROES Act to pause loan repayment obligations?
Your Honor, we're not challenging it in this case.
I know, but the question is, do you think it's within it? This kind of goes to the scope of waiver modify, right?
Yes, I think that so if I can go through the timeline to explain. So the first 7 days on March 20th, 2020, Secretary DeVos waived but didn't indicate what legal authority she was using. I have no way to assess that because I just don't know what authority she was using. Then Congress came in 7 days later and enacted the CARES Act. The CARES Act put a payment pause in place for 6 months. At the end of that 6-month period, Secretary DeVos extended it for 3 months. I think arguably that was a legitimate use of the HEROES Act because taking a congressionally created 6-month program and extending it for 3 months seems like it might be a modification. But now that we're 2 years down the road, we're beyond a modification. And not only that, the connection to the national emergency has become even more tenuous.
So your argument is that even assuming that Secretary DeVos initially had the authority to, and you're kind of just whiffing on the question about before the CARES Act was passed, right? But you're talking about after the CARES Act was passed, she arguably had authority under the HEROES Act to extend the pause, but that at some point as that time dragged on post the CARES Act, when the new administration came in, then it exceeded the authority to waive or modify?
Your Honor, it could have been the Secretary DeVos had 2 extensions. It could have been her second extension. I don't think it hinges on who the administration was. At some point, I think it goes beyond a modification and the connection to the national emergency became too tenuous to maintain it.
So it's not that a pause is different in your mind than canceling the obligation to repay the principal. It's the, or I guess it's a combination of the distinction between a pause and a cancellation and then the temporal
Correct.
Reach?
Correct. Because I do think there are significant distinctions between a pause and cancellation. I'll give you a few. The first is a pause maintains the status quo. Cancellation puts people in a far better. This cancellation puts people in a far better position. A pause keeps indebtedness from rising versus cancellation erases indebtedness. In addition, as I mentioned before, the connection to the national emergency. When you put a pause in place, when the nation is still dealing with lockdown conditions, that is there's a pretty close connection between that and a national emergency. When 2.5 years down the road, the secretary, having much time to contemplate the situation, comes in and creates a debt forgiveness program for 95% of borrowers, the connection to the national emergency is too tenuous.
I understand. Second question's on standing. Could Missouri file suit to vindicate the interests of the city of St. Louis?
No, Your Honor, because when we look at the factors that we've cited for why Mohila is a state-created and state-controlled entity, the leadership of the city of Missouri is not selected by the governor or by the state. They're selected at the local level.
Thank you. Mr. Fletcher, go ahead. I have 2 questions. One is kind of focusing on a different part of the statutory language. Is there a difference between resides and remains? Because they appear in different sections, and it seems to me like resides could mean take up residence in, which might be different than remains.
So I think I've puzzled over this too. I'm not sure if there's any difference in them. I think if by take up residence in, you're referring to the interpretation that Judge Collins floated in his dissent, where it suggested encouraging someone to reside in might mean take up residence for the first time and not continue unlawful residence. The reason why I don't think that works is because of the description that the statute has of the mens rea. It says knowing that the person's coming to or residing in the United States is or will be unlawful. And I think that suggests that Congress understood that you could violate the statute by encouraging someone to continue residence that is already unlawful.
And that's
Okay.
the, I'm sorry, go ahead. No, I'm sorry.
And my second question is about the effect of the enhancement. So a jury has to find the elements of the enhancement.
Correct.
Okay. So in thinking about this as an overbreadth challenge, I mean, obviously the substantive offense itself could, standing alone in a situation where the penalty or the enhancement wasn't applicable, let's just posit that maybe that violates the First Amendment and fails in an overbreadth challenge. You say there's no evidence for someone bringing an overbreadth challenge in a situation like this where you can combine it with the enhancement that requires the financial gain. So I just want to be sure that's right.
That's right.
That's right.
Right. We haven't seen any precedent for an overbreadth challenge like that, and we don't think allowing the extension of overbreadth to that sort of challenge is consistent with the principles of overbreadth, which include that if there's a way to sever invalid parts of the statute and leave the rest, courts ought to do that. And we think that's exactly what's true here. Even if you thought, as your question posits, that the general offense is potentially overbroad, I don't think that would mean that the enhanced offense is overbroad. It's a severable class of offenses.
Wait a minute.
Precisely
So is it
because
when it's two defendants then that it kind of seems to me that your rule leads to the conclusion that if you have only two defendants, because I had the same question as Justice Alito about me and a few other guys. The factual difference here is that there was one other guy. So is your rule then that it's not possible if you say me and another guy to ever try just two defendants together if you have a non-testifying confession?
I think that it is one of the contextual factors, and when you look at what lower courts have done, I think lower courts have differentiated between cases where, for instance, you have a confession that refers to multiple people and there are multiple defendants on one end of the spectrum, and on the other end of the spectrum, a case like this where you refer to the other person, and there's only one person who that could plausibly
but
be.
Mr. Shamigam, in your reply brief when you were talking about how you could redact it further, I mean, I guess I'm kind of drilling down on Justice Alito's point here. It seems to me, without rewriting it to make it misleading so that there's no reference to there being another person in the car, you couldn't really, because there's a difference between substitution through a placeholder and then just kind of rewriting it so it doesn't represent the same thing. So it seems to me at the end of the day it boils down to you just can't try two defendants together if you have a non-testifying defendant in the confession.
I don't think that that's true, Justice Barrett, and I would recognize that there are going to be cases where redactions, further redactions are more feasible or less feasible. In this case, precisely because the confession came in through an interviewing agent, it was obviously not a verbatim account of the confession even to begin with.
Well,
but we do think
Justice Barrett.
So, Mr. Mubin, when you were having this colloquy with Justice Kavanaugh, y'all were talking post by post. The Chief Justice asked you at the start, are we looking at this as whose account is it, or are we looking at specific actions? It kind of sounded to me when you were talking to Justice Kavanaugh that your position, which I kind of understood your initial position to be, no, we're looking at the account, but which is it?
So I think it's true that you're looking at the account and the blocking, but as I told the Chief Justice at the very end of our colloquy and now with Justice Kavanaugh, if you use the account, even in part, for what is an exclusive governmental duty to give notice to the public or engage with the public, I agree at that point it's going to be state action. The reason why I think it's important to think about this at the account level is there's a lot of speech that might be viewed as official, but isn't an official duty to provide information to people in like the hypotheticals Justice Kavanaugh was asking me. And so a way of differentiating the two. Announcing, for example, that I'm going to sign a bill, announcing I'm going to appoint a judge. Those sort of things are things you could do even if you view those as official in some sense, that doesn't mean that you're using the property where you make that speech in an official capacity. You can engage in that type of speech at a campaign rally, at a church, in your backyard.
So we are kind of looking post by post, I think.
If you're talking about exclusive duties, I agree with
Okay. And I have a question about this word duty. So what is the point of talking about both duty and authority? Because it seems to me that duty, and this kind of runs throughout the brief, sometimes it's described as obligations. You described it just now as an exclusive government duty. a requirement that appears sometimes in the briefs, but sometimes there are things you have the authority to do as a government official that you're not required or obligated to do. So it seems to me that if you have the authority to do them, something that you have a duty to do is just a subset of authority. So why are we talking about duty?
So look, I think you're right that duties and authorities in some sense are flip sides of the same coin in general, and that you can have exercises of authority that are permissive but not required. So I agree with all that. I think authority does add something beyond duty. I think what it's helpful most for is things like the use of staffing, the use of resources, things like that, that don't really directly go to the question of is it duty, but it is the wielding of authority. Now that sort of thing is relevant for two reasons. One, it's good evidence that you're wielding a duty or authority if you're using government resources or staffing. And two, it's possible that at least in some cases, the mere use of those resources alone could be state action.
See, I mean, I guess I just think using the word authority, I mean, I get, and then in the Sixth Circuit case, that's what the opinion seems to be, that's the, I don't know, that's the value of authority, I think, in the Sixth Circuit opinion. But it just seems to me like a weird way to describe it. I think of it more as evidence, right? Yeah. I mean, am I losing a whole lot if I don't want to use the word duty and if I just say authority? Maybe that would pick up some of that stuff that you're talking about anyway?
I don't think you're losing a lot. I think you could frame it either way. As I said, I think they are flip sides of the same coin.
Okay, you were talking a lot about property, which is the government's focus. So you've articulated the test. As Justice Gorsuch said, we have lots of articulations on offer on your side of the V. What is the difference? What's the daylight between the government's position and your position? You know, their focus on, is this private property that the public official is inviting you onto? You know, the test that they propose versus the authority, duty, control test that you do.
So I don't actually think there's any daylight between our positions, though you can ask my friend. They've obviously emphasized property as sort of this initial gating mechanism, whereas we view the fact that it's private property as quite relevant to determining are you exercising duties or authorities of your office. But at the end of the day, I think the cases all sort of cash out the same way. Whether you apply our framework or theirs, you essentially end up in a spot where if you're using a private account and you're not exercising an exclusive governmental function and you're not using government resources and the government can't control it, then you should understand that to be acting in your personal capacity, because people have the right as government officials to talk about their jobs in their personal capacity. And you should assume that when they do that on their own personal property, they're acting in their personal capacity.
Okay, last question. At the beginning of your argument, you referred to unless someone is choosing to use their Facebook account, Twitter account, whatever, in their official capacity. And Justice Kagan's questions were getting to some of this. I think it's very difficult when you have an official who can in some sense define his own authority. So I think for a governor or, you know, President Trump, it's a harder call than someone like a police officer who's a subordinate. Or I could, you know, my law clerk could just start posting things and say this is the official business of the Barrett chambers, right? And that wouldn't be okay. But if, you know, that wouldn't be okay. If, you know, Governor Newsom decides to do it, he has the authority to define the scope of his authority. I would have thought in your client's context, they don't actually have full-ranging authority just as board members, right? Unless the board said, we've taken a vote, and you are the one who's our communications person. You are the point person on communications. Then you would look at a source of authority. But if in that context, I mean, I guess it just kind of depends official by official. I guess I'm not understanding in your specific for your client why there would be an argument even. It seemed like you were conceding a little bit and talking to Justice Kavanaugh about official announcements and that sort of thing. Would that be true for your clients?
Yes, I think if my clients, you know, if for example there was a slush fund at the board to, you know, use money for doing your job, and my clients use that money to like buy a Facebook account or use advertising on Facebook, I don't think my clients would be acting in an ultra vires fashion, and I think that that would be exercising state action. Now, I do agree with you, Your Honor, that on the control piece of using control as evidence of whether it's governmental or not, it becomes harder the higher up you go in the chain because it's harder to identify a superior who can tell you what to do. But even take, for example, the governor of California. Well, the governor of California does have a boss. The boss is the people of the state of California who could, for example, amend their constitution. And they could amend their constitution and say that even the governor, when he's exercising his official capacity, here's what he can and cannot say on a social media page. And they certainly could not do that for this sort of page, for a page that he owned before he was the governor, that he will own after he's the governor, and that he uses only to say things that under Lane he has a First Amendment right to say in his individual capacity.
Justice Barrett?
My question's on the law-abiding and responsible also. I guess I understood our use of that phrase in our prior cases to describe the would-be gun owners in those cases. Like, we're not talking about who might be able to be disarmed. There might be other people, but all of those people were law-abiding and responsible, and there was no allegation that they weren't. But it seems to me that in your brief and in parts of the argument, the government is asking for that to be a test, but I don't think we presented it as a test. Do you see a reason for us to use that as the test, law-abiding and responsible, given some of the ambiguities in that phrase?
So I wouldn't describe it as a test. I guess what I would do is describe it as the relevant category, the shorthand to get at the idea that legislatures consistent with the Second Amendment can take action to disarm particular types of people whose possession of weapons present these types of concerns, either that they have committed serious crimes or present a danger. And I would use this as shorthand in the same way the court has referred to the sensitive places principle or the dangerous and unusual weapons principle.
So could I just say it's dangerousness? Let's say that I agree with you that when you look back at surety laws and the affray laws, et cetera, that it shows that the legislature can make judgments to disarm people consistently with the Second Amendment based on dangerousness. Why can't I just say that?
We certainly agree that that's what history and tradition show. We think that defines the scope of the category of those who are not responsible. We don't think dangerousness is the standard with law-abiding, and I recognize you might have some different views on that, Justice Barrett. You don't need to resolve that issue here. This is a case just about someone who is not responsible in the form of being dangerous. So yes, we would be happy with a decision that says legislatures for time immemorial throughout American history have been able to disarm those who are dangerous.
But you're trying to save like the range issue. So you're not applying dangerousness to the crimes.
That's correct. We think that there are additional arguments that can be made to defend felon disarmament, and that those depend on the unique history and tradition with respect to criminal conduct. And so we would hope to have the opportunity to present those arguments and perhaps persuade you in a future case. Okay. Yes.
Thank you.
I thought you just said no. I thought you said there's no history of any kind of ban for anything that doesn't relate to felonies.
I want to be clear that there is no one that I've found anyway. I think it would stem from a court's either historical equitable powers or the rights of the government to literally protect someone from imminent danger to life and limb. There are examples, some of the early Justice of the Peace manuals that talk about if you see someone who is on the way to commit a crime with a weapon, you can take the weapon away from them and you don't have to institute proceedings immediately. However, you do have to institute them pretty quick after that.
I'm so confused because I thought your argument was that there was no history or tradition, as Justice Kagan just said, of this kind of disarmament in this circumstance. But now it kind of sounds like your objection is just to the process. Like, are you making Judge Ho's argument only?
No, Your Honor, I'm not making Judge Ho's argument only. The law that's before us right now is a ban. It's a ban that's passed by a legislature, and it is, you can't get around it. You can't even ask the state court to say, I will accept a protection order, a stay-away order, just give me permission to keep firearms for my own self-defense. That will not prevent this ban from kicking in, and it has severe penalties that result from it, and it applies everywhere, even in the home. I think all of those things together make this statute unconstitutional. I understood the question to be, what about something else? Would that be constitutional? And I think so, but we would need to know, we do need to do a full workup on the history and tradition that supported that. That's something that I don't think this court can answer in this case because there's no such law before the court.
Well, Justice Barrett?
So the restraining order prevented your client from possessing a firearm, and it also immediately suspended his handgun license. Was that unconstitutional?
Your Honor, just to take issue with the second part of the question first, that language, suspending handgun license, that's in all of these Tarrant County orders. That's part of the boilerplate.
But still, it says it's ordered that his handgun license is immediately suspended. So
Right.
just let's go with the orders language. Did that violate the Second Amendment, putting 922 aside?
I think to answer that question, then we would bring the whole record, the record that was before the court in terms, and the client agreed to the order. So it would be very difficult.
But you're going back to the process.
Right.
You know, she had the affidavit. Let's imagine they go back and forth. Let's imagine it's a more fulsome process, and she actually testifies, and he cross-examines her. Whatever. Let's assume there's no process problem. Would it be unconstitutional then to deprive your client of his handgun license and his prohibit him from possessing a firearm? Because I assume that you've said there's no analog of this kind of domestic violence.
Right. Or the analog would be in terms of what courts could do through equitable powers otherwise. I think that would have to be the
But
analog.
they can't, through their equitable powers, do something that would violate the Constitution, right?
Right, right. So if the finding was that nothing short of surrender of firearms would prevent damage to life and limb, that would be constitutional. I don't know if that answers your question or not. But